OLC opinions, Office of Legal Counsel, by this administration. Here again, this is nothing new, but the degree and depth and secrecy of which I think is new and very, very troubling, again, as an activity that undermines respect for the rule of law, separation of powers, and the legitimate power of the Congress to conduct oversight of the executive branch. I quote just one, and we still don't even know the extent of even this one memoranda from 2001 because it remains still classified. But this was a memorandum that indicated that, quote, the Fourth Amendment had no application to domestic military operations, close quote. I mean, what in the heck is the administration talking about? First of all, about domestic military operations, and secondly, to display the audacity to declare that the Fourth Amendment does not reach and does not surround those operations, whatever they are, with the protections of the Fourth Amendment to our Constitution. That is the depth, I think, of the lack of understanding of the fundamental institutions of our government that have been displayed by and disdained by the current administration at a level taking them far beyond those problems that we have seen in prior administrations. This is not a problem with a particular president. It is not a problem with a particular administration, although the degree to which these problems have manifested themselves with the current administration is problematic. This is an institutional concern. For one thing, Mr. Chairman, every administration, in my view, and I think history bears this out, takes the power that it inherits from its predecessor and considers it a floor, not a ceiling. So if we don't get a handle on this now in some form or fashion, the next administration and the one after that, regardless of party, will take these abuses, these powers, these liberties with the fundamental institutions of our government and take them to even higher and higher levels. So I commend the Chair and the members of this committee for taking hold of something that could not possibly be more important, and that is the fundamental underpinnings of our constitutional system of government. I thank the Chair.
Our constitutional system of checks and balances assumes a certain jostling between the President and Congress, but the Bush administration's refusal to provide information to Congress and to the American people, the Bush administration's insistence on acting in secret, is more dangerous and more sinister than just an extravagantly ambitious claim to executive branch powers. Control of information stifles dissent. It insulates an administration from challenge, either by Congress or by critics. Control of information is incompatible with democracy. Informed criticism, as annoying as it frequently is to people with power, is the stuff of democracy. Democracy dies behind closed doors. It is Congress's duty to throw the doors open and keep them open in future administrations, Democratic and Republican alike. And it is not just Myers and Bolton and Rove. Every committee has been stiff-armed by the Bush administration in our exercise of our oversight powers. Those disputes will not be resolved before the election in November or by the inauguration in January, but those disputes will not be moot next year. We must continue our effort to learn how the Bush administration has used the powers of government, and we must restore the balance of powers between Congress and the President, regardless of who is President and regardless of which party is in the majority in Congress. I have introduced one bill just last week to restore Congress's checks on presidential power, especially the power to act in impregnable secrecy, and I expect to introduce another shortly. Ms. Lofgren asked for practical suggestions on how to right the balance between the branches of government, how to restore the separation of powers and the checks and balances that the founders of this republic intended, and that has been my aim. The first bill, H.R. 6508, Chairman Conyers is the co-sponsor, Mr. Nadler is as well as Ms. Sanchez, and obviously I'd welcome additional supporters, would allow the House to ask a court to appoint a special prosecutor for a criminal contempt of Congress charge where the United States Attorney refuses to present the case to the grand jury. In recent history, Congress has enforced our authority to take evidence